Welcome to Q&A practice. Let's start out with a little bit of warm-up. And we'll start with the defense attorney. Ready? Here we go. So the issue that became posed for you as a potential expert in this lawsuit was whether this power steering belt came off before the Burns vehicle went out of control and had a collision. That is one of the issues. Yes, that is the one that you principally addressed yourself to here in court, is it not? That is correct. You were given a power steering bracket and it was immediately obvious to you that the number 2 boss had not been machined. That is correct. After you got a look at the specifications and drawings, it was clear to you that the bracket did not meet all those specifications. Is that right, sir? That is correct. And in examining the bracket, you noticed that there was some deforming of the bracket which you felt was consistent with the trauma or blow of running into the hill. That is correct. And you came to the conclusion that in that collision the power steering pump was actually moved with relation to the bracket. Yes, it was from your examination of the parts that you felt there was a misalignment. That is correct. And you have concluded from looking at the bracket and the marks that you have described here that there probably was some misalignment at the time of the accident. That is correct. You were unable as the metallurgist to tell us how much misalignment there actually was following Mr. Baldwin's attempt at aligning the bracket. I can't tell you how much. Where you told Mr. Collins had found a spacer at the second boss, but it had not been preserved. I don't remember ever being told anything with regard to that spacer in that context. Now we'll get to our transcript. Hopefully you're feeling a little bit warmed up. And we will start with defense attorney. Ready? Here we go. Okay, more than half or less than half, but you don't recall how many he was able to purchase at specifically? No. Or how many you visited with this individual at this time? No. Okay, I have no further questions. Anything further, Ms. West? No, I have no further questions. Thank you, investigator. Just wait out there. At this time, I'd like to enter my exhibits into evidence. Any objection to 2 or 3, Mr. Morris? No objection. 2 and 3 are received. Department rests at this time. Your Honor, I think at this juncture I'd like to just ask for a ruling on the motion to compel discovery, which was drafted and filed by the respondents, and opposition, I believe, was prepared by the department. It is the same motion that you always hear, or I guess Judge Norris, the one that is always hearing them, but we don't have a ruling on them yet, so I'd like for one if possible. I don't know anything about that, and this is not the time to bring a motion to compel discovery. Well, did you have a conference call? Let me look at my notes. There's nothing in my file about a motion regarding discovery, and it's not timely as far as I'm concerned. Well, the motion had been filed. I'm not making it now. It's just the ruling hasn't been made by the department. Has it been argued in the conference call? Let me look at my notes. Well, my notes don't indicate anything. All right, when did you file it? This motion was filed on the 16th of July of this year. Yes, Your Honor. And what are you seeking? Well, would you like to take a look at the motion itself? No, I want you to tell me what you want. Okay, Your Honor, I feel that you've already said this motion wasn't timely. Well, I don't know if it is or it isn't. At this point, I haven't seen it. It's normally not timely at the time of the hearing, but if it was only filed July 16th, maybe I misspoke. Can we take a brief recess? Why? So I can pull all these documents and take a look at them. Why are you just doing that now as opposed to making an issue out of this before the hearing? Have you ever had such a motion heard at the hearing? I have requested rulings at the hearing. You have? Yes. And what happened to that? They've always been denied. Okay. However, before the respondent proceeds with this case, I'd like to get a ruling on that to preserve the issue. And you can't tell me what it is you're seeking. Yes, I can. If I could just have a moment, I will. Off the record, back on the record, Mr. Morris, when did you file your request for discovery? The request for discovery was itself filed on August 5th, 2006. And the department, you got some discovery? Yes, we received the response from the department on August 25th, 2006. And what did you do thereafter? And the one category of information which was requested, that is at the heart of the motion to compel, is the following, and I'll just read it verbatim. All right, slowly. Okay. Any and all investigative and or supplemental reports prepared by or on behalf of any and all law enforcement agencies, including but not limited to police departments, sheriff's departments, Department of Alcohol Beverage Control, pertaining and or relating to any violation of Business and Professions Code 25658 and or any citation issued for such violations involving minor Mark White on or about March 21st of 2006 at any and all locations where such violations occurred, including but not limited to any and all locations where a citation for such a violation was issued. That is the one category of information that's at the heart of the motion. So you want to know what the department has concerning other violations involving this particular decoy on the same date. Yes, even non-violations, the places where they visited. So essentially, so we can interview and conduct for the discovery as to what those other locations opine, particularly with respect to the appearance of this decoy. Ms. West, do you wish to be heard? Yes, I don't think this motion is timely at this point. In my file, I do not have a copy of their motion to compel. I'm not saying they didn't file one. I'm just saying I don't have a copy in my file. We responded to their discovery request on September 25th. The notice of hearing in this matter was received on October 4th. According to Mr. Morris, 2 weeks later, on October 16th, they then filed their motion. It seems that that's not a once they received notice of the hearing. Since this is a form motion, it should have been filed immediately. Since this is a what motion? A form motion. They make this motion in every case. It just never gets to you because they're heard before the hearing. There is a telephone conference with Judge Norris, so you never hear them. It's resolved before we get to this point. It's one of their forms, just motions to compel, that they send out in every one of these cases. Do you agree with that? Generally, yes, I do. If this, again, I have nothing in my file, so I'm just assuming, I'm going to assume they filed a motion and we filed our form response. They should have insisted on this motion being heard prior to the hearing. I mean, to come in here at this point and say we want further discovery, it's too late. They should at least have to establish good cause why they didn't insist on having this argued sooner. If you want me to get to the merits of what they're asking for, I would be happy to address that too. Sure, I'll hear that while we're at it. Basically, they are asking for any reports generated in regard to other locations that sold to this decoy. We are not required to provide that information. We do provide the other side with that ABC form that was referred to earlier, the 338, which lists every location that was visited, and it lists the locations that sold and did not sell. According to the appeals board, that's all we have to provide to comply with discovery. If they want to conduct further investigation, they have all the information they need on Form 338. They have the addresses, the names of the locations, and whether or not they sold. We have complied with discovery by providing that information. That's all the appeals board requires. We are not required to provide them with other investigative reports, and in fact it could be a violation of certain privacy rights of people involved in those reports to provide that information. All right, Mr. Morris, on the merits, Your Honor, I do have a memorandum of points and authorities that I'd like to provide you with an opportunity to review. No, I just want you to argue it orally. Okay, well, our position is that this request for this information is within Government Code 11507.6, and as far as you know, routinely this motion has been denied by Judge North. Yes. In other cases, yes. All right, okay, I'm persuaded by that. Number one, not having had an opportunity to review all the papers, and number two, I don't think it is timely. And I'll say that just looking at the APA under section 11507.7, motion to compel discovery, it suggests to me that the motion to compel discovery needs to be served and filed within 15 days after, in this case, Mr. Morris's side first learned of the failure to comply with the request to discovery. And it was, and that was September 25th, and October 16th is not within 15 days of September 25th by my calendar. Those are the dates you gave me. I believe, Mr. Morris, you said you've got the department's discovery motion was filed on October 16th. The response was provided, was received on September 25th. Yes. So that was your starting date for 15 days according to the section I'm reading, because that's you got a response. It didn't include what you wanted, what you're asking for now. So you had 15 days, and that puts your request outside the 15 days. Yes, because you said you made the motion on the 16th. Yes. Okay. So that's my second reason to deny the motion at this point, but I will say I'm also persuaded by Ms. West. All right, that will conclude our Q&A practice.